Good morning. Thank you so much for joining us today on our Wednesday webinar. Today, we are going to talk about Social Security disability for lung cancer. Before we go any further, I want to give my typical disclaimers, which is that today's webinar is not meant to serve as legal advice, but is instead meant to serve as additional background information for individuals who may be considering applying for Social Security disability benefits due to a lung cancer diagnosis. The other thing that I want to say up front is we don't take any live questions on the live webinar, and we don't really respond to questions in the comments on the replay. And the reason for that is not because we don't want to help, but it's because we often need a lot of details to actually get any good answer to a question that you may have. And we don't want you to be putting that information out there. A lot of it is health information. So we just ask on the live, we'll go ahead and drop a link in the chat now if you'd like to schedule a call with us. And then on the replay, that link to schedule a call will be down below. Please do feel free to schedule a call if you have any questions. We are always happy to help in any way that we can. And if for some reason we cannot help, we do try to point you in the right direction of somebody who may be able to help. So with that out of the way, let's go ahead and get started. Here's our roadmap for today. We're going to start out by talking about Social Security disability basics. We'll then talk about some guidance from the agency. We'll talk about the listing that covers lung cancer, some additional considerations, and then we'll close out the webinar by talking about how an attorney may be able to help you with your Social Security disability claim. A little bit about me. My name is Caitlin Wildoner. I'm the founding attorney of Beacon Disability PLLC, which is a law firm based in Florida, where we exclusively practice federal administrative law, and we help claimants with their SSDI and or SSI applications from the initial application sometimes all the way through to the appeals council. So we focus our efforts on the agency actions. We do not handle federal court appeals at the time of this webinar. All right, here are the basics. There are two different Social Security disability programs. There's SSDI benefits, Social Security Disability Insurance, and there's SSI, Supplemental Security Income. Both programs are going to require that you be disabled and unable to work for a period of at least 12 months due to either mental and or physical impairment. Where they differ is SSDI is going to require that you have a certain work history. You must have paid into the Social Security system long enough to have benefits there that you can draw from. SSI does not have the same work history requirement, but instead it has income and asset restrictions. The income restrictions we don't cover in the webinar because they vary depending on household size, but the asset restrictions are pretty black and white. You cannot have more than $2,000 in assets if you are single and more than $3,000 in assets if you are married and still qualify for SSI benefits. When I say that you've got to be disabled and unable to work for at least 12 months, that does not mean that you need to wait 12 months before applying for benefits. And in fact, I often discourage people from waiting 12 months before applying because number one, the process is lengthy. Number two, it may have an impact on your date of eligibility for benefits, especially with respect to SSI, for example. With SSI, the agency cannot pay benefits prior to the date of the application. So let's say you get into a car accident in January and you don't apply for SSI benefits until the following January, you just lost potentially a year of SSI benefits. So that's why I do encourage, as soon as you and or your doctors think that you're going to be out of work for at least a year, go ahead and apply. It's a lengthy process. The worst thing that's going to happen is Social Security is going to say, nope, you're not disabled according to our rules, and you can start the appeals process. The other thing the agency sometimes does is they'll hold on to your case. They'll say, well, we got your case. We, understand what you're saying, that you may feel that you're disabled and unable to work. We're going to hold on to your file until 3 months from now. And then we'll pull updated medical records and we'll conduct our review at that time, usually to see how things have progressed, whether they've gotten better, worse, stayed the same. And I've seen this particularly in cancer cases, which is relevant to what we're talking about here, where, if you start treatment, they will kind of hold off a little bit to see what the side effects from the treatment are. Is one round of treatment going to be good enough, or are you going to have to go through multiples? So there's a lot of different factors at play, and I always recommend applying sooner rather than later. Okay, I've had many instances where I talk to somebody and we're dealing with a remote date last insured, meaning, they last worked 8 years ago, maybe. And so their date last insured for SSDI benefits is back in 3 years ago. And those cases are a little bit more difficult because medical records are harder to get. You have missed out on a chunk of potentially available benefits. So always, as soon as it looks like you're going to be disabled and unable to work for at least a year, go ahead and apply. If it doesn't last a whole year, if you're able to go back to work within that year, that's great. Then you can go ahead and withdraw your application. Say I was able to get back to work at this time. And that, there's no harm in that. So those are the two programs, and a little bit of an overview kind of on the timeline. Here's the 5-step evaluation process. When you first submit your application for either SSDI or SSI benefits, the very first thing, kind of step 0, that the agency is going to look at is if you've applied for SSDI, do you have a sufficient number of work credits? If you don't, they're going to deny it right away. They're going to say you don't have a sufficient number of work credits, therefore you cannot qualify for SSDI. With SSI, this step 0 is, do you have below the income and asset thresholds? If you do, then they'll move on to this 5-step evaluation process. If you don't, if you exceed the income or the asset threshold, you'll get a denial saying that you are not eligible for SSI benefits for that reason. Okay. As long as you meet that prong in SSDI and or SSI, here's the 5-step evaluation process that they will follow. They first look to see, are you currently engaging in substantial gainful activity? That means in 2023, are you working more than 20 hours a week, or are you earning more than $1,470 a month? If you're doing either of those, then you're engaging in substantial gainful activity, and the agency won't go any further. You'll get a denial. They'll say you cannot be found disabled under our rules because you're currently working, even if that's only 20 hours a week, 25 hours a week, and you're earning $1,500 a month, and you're saying, well, that's not enough. I can't pay all my bills. That's understandable, but that's what the agency is looking at. By their definition, you cannot be found disabled because you are engaging in substantial gainful activity. As long as you're not engaging in substantial gainful activity, the agency moves to step 2, where they review the medical records and they see, do you have one or more severe medically determinable impairments? As long as you have one or more severe medically determinable impairments in the medical records, they'll move to step 3. If you don't have any severe impairments, they'll deny it at step 2, saying you're not disabled under our rules, you don't have any severe impairments, you can go to work. If you have at least one, they'll go to step 3. They're looking at the medical records to see, do you meet or equal one of their listings? The listing that we'll talk about in just a minute for our particular instance that we're covering right now is for lung cancer. So they'll go to look at that listing to see, do you meet or equal that listing? If you do, analysis stops there. They'll send you an approval saying you are disabled under our rules, and then you'll get the notice of award and all of that. If you don't meet or equal a listing, the agency will create a residual functional capacity for you, which is what the agency believes you are capable of performing on a continuing basis in spite of your condition. They'll take that RFC and they'll compare it to what your past work is in the past 15 years, your past relevant work. And they'll say, okay, can an individual, your age, education, work history, and RFC, can that individual perform your past work? If you can perform your past work, you'll get a denial. The agency will say, nope, you're not disabled because you can go back and do this job. If you cannot go back to your past work, they'll go to step 5. They'll use that same RFC, age, education, and work experience, and they'll say, okay, is there any other work that this individual can adjust to in the national economy? If yes, you'll get a denial. They'll say you can adjust to other work. If there is no other work that you can adjust to, then you'll get a favorable decision at step 5. All right, here are some considerations that the agency makes, particularly as it relates to cancer cases. When evaluating a case that involves a cancer diagnosis, here's what the agency is looking for. They want to know the origin of the cancer, the extent of the involvement, the duration, frequency, and response to anti-cancer therapy, and the effects of any post-therapeutic residuals. Social Security will apply the listing to the cancer that originates from that specific site. So the listing that we're going to look at in a minute for lung cancer is going to cover cancers that originate from lung cancer. If it has started somewhere else and it's metastasized to the lungs, then you're going to want to look at the site origination, that listing. Okay. As always, if you don't meet a listing, the agency will then go ahead and evaluate your residual functional capacity to engage in substantial gainful activity, whether that's your past relevant work or any other jobs that exist in the national economy. When it comes to medical records, Social Security wants to see medical evidence that specifies the type, extent, and site of the primary, recurrent, or metastatic lesion. If the primary site cannot be identified for some reason, the agency will use evidence that documents the site of the metastasis to evaluate the impairment under this separate listing of 1327. They're also going to look for any operative reports, including pathology reports, and they want to be able to see any evidence of any potential recurrence, persistence, or progression of the cancer, the response to the therapy, and any significant residuals. So that's why, like I said before, they very well may hold on to your case file for a few months to see, okay, how's the response going to happen? Okay, is the cancer going to respond to it? Is it going to be, is it going to metastasize during the process? What's going on? Let's hold on and see what happens. So here is the lung cancer listing specifically. Again, this is going to be for cancers that originate in the lungs. Okay, if it's metastasized to another location or it's started somewhere else and it's metastasized to the lungs, this listing is not going to be the one you're going to want to hang your hat on. But as you can see, it's a pretty high bar. There are 3 different paths to meeting this listing: 1314A, 1314B, and 1314C. They're all independent of each other. You would just need to meet one of the 3 in order to meet listing 13.14 for lung cancer. And again, it's going to be talking about cancer that originates in the lungs, not cancer that has metastasized to the lungs. Here are some considerations, and these are kind of more general. As always, as you can see, I put on the slide twice, and if you've watched any of our other webinars, you know I talk about it twice. Medical records are important. The issue in Social Security cases is not just can you go back to your past work, but is there any job that exists in the national economy that you can perform? This is really, really hard for a lot of people to understand, and I understand why. You know, let's say you're 45 and you've given the last 20, 25 years of your life to the nursing field. You don't know anything else. The agency is still going to look at that and they're going to say, okay, thank you. You've got a great work history, but it doesn't, your transferable skills are not going to dictate what you can go back to. You're under 50, you can learn new tricks. Okay. So if you are 50 or older, then the grid rules may apply. And that's kind of where we look at that past relevant work to see whether you have transferable skills to other jobs and things like that. Functional capacity can also be relevant, especially if you don't meet or equal that listing. And again, objective medical records are important. In cancer cases, that tends to be operative reports, pathology reports, even therapy visits, showing the frequency and kind of what the side effects of the medication. The side effects and what you're experiencing are not as objective, but the frequency of the visits is certainly an objective point to make. Especially if the doctor is also notating that, yes, these side effects we often see in patients that are on this particular anti-cancer therapy. All right, here is a non-exhaustive list of different ways an attorney may be able to help you. We can provide guidance on what correspondence from Social Security actually means. We file necessary appeals if you are either already a client of ours and we get a denial, or you reach out to us after receiving a denial within enough time to allow us to get that filed on your behalf. We review the medical records in your case file. We can discuss what additional records may be helpful in your case. Sometimes there are none. Sometimes there are. So it just depends on the specific situation and also the accessibility of that option to you. We review documents for accuracy and completeness and discuss what Social Security is looking for in their requested forms. We cannot fill those forms out for you because I'm talking about the forms that the agency will send after receiving an application or reconsideration appeal, where they're asking, your day-to-day activities, your supplemental pain questionnaires, supplemental cardiac questionnaires, those kinds of things, because we are not in your shoes. So we can discuss what they're looking for. We can review them for accuracy and completeness. We can send them to the agency, but we cannot complete them on your behalf. We do work with you to provide relevant updates from Social Security and to Social Security throughout your claim. We prepare you for the hearing with administrative law judge, and we would question you and any witnesses during that hearing. And as I try to often remember to say, the witnesses are not necessarily family members, friends, and prior coworkers, but they are witnesses that are brought on by the agency, such as a vocational witness or a medical witness. Here's our contact information. If you have questions, we'll go ahead and drop a link in the chat again to schedule a call. If you have questions, please feel free to give us a call directly, send us an email, reach out to schedule a call, either using the link that we're going to go ahead and put in the chat on the live or in the link down below on the replay. Always happy to help in any way that we can. And as I said before, if for some reason we are not able to help, we do try to point you in the direction of somebody who can. So thank you so much for joining us today. Have a wonderful day.